Today, we are diving into an important distinction within human rights law: inalienable rights and qualifiable rights. Understanding these differences is crucial for recognizing the limits and protections of your rights, especially in emergency situations, and can help shed light on how rights are sometimes manipulated or misunderstood. What are inalienable rights? Inalienable rights are fundamental rights that cannot be surrendered, transferred, or taken away under any circumstances. These rights are considered inherent to human beings, meaning they are essential for human dignity and freedom. The key aspect of inalienable rights is that they exist independently of legal systems or government decisions. They are not subject to change or limitation by laws, policies, or state powers. Examples of inalienable rights might include the right to life, liberty, and personal security. These are often considered the core human rights, enshrined in international human rights instruments like the Universal Declaration of Human Rights, UDHR. What are qualifiable rights? Qualifiable rights, on the other hand, are rights that can be limited or restricted under certain circumstances. These rights can be subject to legal frameworks that allow for qualifications, limitations, or suspensions, especially in situations where public order, security, or emergency situations require it. The European Convention on Human Rights, ECHR, is a prime example of a legal framework containing both inalienable and qualifiable rights. While it guarantees certain fundamental rights, such as the right to life and prohibition of torture, it also allows these rights to be qualified under exceptional circumstances. For instance, the right to freedom of expression can be restricted in cases of national security concerns, or the right to privacy might be limited in the event of an emergency. Differences between inalienable and qualifiable rights. Inalienable rights cannot be altered or taken away, regardless of the situation. These rights exist simply because someone is human. Qualifiable rights can be altered or suspended depending on specific circumstances, such as emergencies, public safety concerns, or national security issues. They can be limited by law and government discretion. Emergency situations and the impact on rights. Let us now look at how rights are handled in emergency situations. 1. Inalienable rights in emergencies. Inalienable rights, by definition, should not be violated even in the face of an emergency. For example, during a national crisis, such as a pandemic or a war, individuals still retain their right to life, and the prohibition against torture or degrading treatment should remain absolute. 2. Qualifiable rights in emergencies. Qualifiable rights, however, are subject to suspension or restriction in emergencies. Governments might invoke these qualifications to restrict freedoms, such as the right to assembly, or to place limitations on movements for public safety reasons. The ECHR explicitly allows certain rights to be restricted during states of emergency, but these restrictions must be temporary and proportional. For example, during the COVID-19 pandemic, governments implemented restrictions on freedom of movement, and in some cases, enforced curfews. This could be justified under the principle of qualifiable rights, where certain rights can be curtailed for the greater good of public health. However, the core inalienable rights, like the right to life, should still be protected. The European Convention on Human Rights, ECHR, and inalienable vs. Qualifiable rights. The ECHR enshrines a wide array of human rights, some of which are inalienable and others which are qualifiable. Inalienable rights under the ECHR. These would include rights such as the prohibition of torture and slavery, Article 3, and the right to a fair trial, Article 6. These rights are non-derogable, meaning they cannot be suspended, even in times of war or emergency. Qualifiable rights under the ECHR. These rights include freedom of expression, Article 10, freedom of assembly, Article 11, and the right to privacy, Article 8. These rights can be restricted in certain circumstances, like protecting national security, public order, or preventing crime. Gaslighting and misunderstanding rights. One of the most insidious aspects of legal discourse surrounding human rights is the gaslighting of citizens into believing that their rights are solely qualifiable. This means that people are often led to think that their rights are conditional, that they only have access to basic freedoms when the state permits it, or that these freedoms can be easily suspended when the government deems it necessary. This narrative is especially prevalent during times of crisis. Governments may use emergency powers to justify limitations on civil liberties, framing it as a necessary step for public safety. But this can easily lead to a public misconception that rights such as freedom of expression or the right to privacy are always subject to the state's control, which isn't true. For example, when governments suspend freedom of assembly or impose curfews during emergencies, they may frame these actions as reasonable and acceptable restrictions on qualifiable rights. But people may begin to internalize the idea that they don't have inalienable rights at all, just rights that can be revoked at the discretion of the state. The UK and inalienable rights. In the UK, the concept of inalienable rights is also a central feature, though it may sometimes seem more abstract because of the way rights are historically framed. The UK's human rights framework, especially under common law, upholds certain rights as fundamental, particularly the right to life and the right to a fair trial. While the UK is a signatory of the ECHR and thus bound by the Convention, there's been debate about whether some of these rights are as inalienable as they should be. The Human Rights Act 1998 incorporates the ECHR into UK law, and there are certain rights in the Act that could be considered inalienable, such as the prohibition on torture or degrading treatment. However, the Act also leaves room for qualifications. For example, the UK could theoretically derogate from certain provisions of the ECHR during an emergency. This dual approach can sometimes create confusion about the nature of rights in the UK. Conclusion. In summary, understanding the difference between inalienable and qualifiable rights is key to recognizing the scope and protection of your freedoms, especially in emergency contexts. While inalienable rights are non-negotiable and remain intact even during crises, qualifiable rights can be subject to limitation or suspension depending on the situation. It's essential for us, as citizens, to be aware of how our rights are framed and protected, because when we are gaslighted into believing we have only conditional rights, it can erode the very foundation of our freedoms. Closing thoughts. When we discuss rights, it's not just about legal definitions. It's about understanding their true protection and the ways in which those protections can be manipulated. By recognizing the distinction between inalienable and qualifiable rights, we can better advocate for our freedoms and demand that they be respected, especially in times of crisis. Please like, share, and subscribe to the channel for further videos.